each of the, so we just had a notification about the recording. I'll start by introducing each of our three distinguished speakers. So starting with Ms. Dr. Federico Ast. Federico graduated in economics and philosophy from the University of Buenos Aires and holds a PhD in management from IAE Business School. He's the founder and CEO of Kleros, a legal tech company using game theory and blockchain arbitration technology in arbitration. As a pioneer in the field of decentralized justice, he has lectured in universities such as Stanford, Oxford, and Columbia, and international organizations such as the UN. He's an alumni at Singularity University and hosts the first Coursera courses about blockchain and legal tech in Spanish. Of course, he's passionate about exponential technologies such as AI, crowdsourcing, and blockchain for social innovation. And we're very excited to hear what he has to say. Next, we have Sophie Nappert, of course, internationally renowned. Sophie is an arbitrator in independent practice based in London. She's dual qualified as an avocat of the Bar of Quebec, Canada, and as a solicitor of the Supreme Court of England and Wales. Before becoming a full-time arbitrator, she pursued a career as an advocate and was head of international arbitration at a global law firm. She is commended as most highly regarded and leading light in her field by Who's Who Legal. And I want to mention also that Sophie is author of a commentary on the 2010 UNCITRAL arbitration rules. She's a regular speaker at conferences and seminars on issues of international arbitration, international investment law, dispute resolution, was a guest lecturer also at Columbia Law School, Harvard Law School, and McGill. She created the Nappert Prize in International Arbitration, open to young scholars and practitioners worldwide, and administered under the auspices of McGill University. And of course, Sophie is the founder of ArtTech, who's also involved in organizing this event for Dubai Arbitration Week. So welcome also, Sophie. Last, but of course, not least, Dr. Sabine Lepic is a lecturer, researcher, a lawyer, and mediator. She has a degree in philosophy of law from the University of Panthéon-Assas and a PhD in law from the University of Paris-Dauphine. She's passionate about exponential technologies such as artificial intelligence and blockchain. She teaches dispute resolution and alternative, and particularly with respect to alternative disputes, such as commercial and investment arbitration, mediation, private international law as well, at prestigious universities such as Université Panthéon-Assas and Sciences Po in Paris. She was a visiting professor at the Sorbonne in Abu Dhabi last April, and she is part of several think tank research centers in France on blockchain governance and AI, as well as mediation and arbitration, and also in Cambridge at the Cambridge FinTech and Regulatory Research Center. She is currently creating a tech service specialized in the identification of future new disputes and regulations, the future of disputes, in partnership with CEMAP, which is the Centre de Médiation et d'Arbitrage de Paris. So thank you to all of our three speakers for being here and to all of our attendees. The format for today is basically, we will start with a presentation from Kleros by Federico, and then we will move into more of an interactive session where the three panelists will be able to discuss, debate, answer some questions, and hopefully clarify some things for all of us, in terms of providing a framework for us to think about all these new questions relating to the new frontier. The objective is essentially brainstorming to build a new vision for the metaverse. We are fortunate and really privileged to have these three experts and pioneers of decentralized justice and new technologies here in live debate in front of us on the problems and solutions of the future of new technologies and their impacts on law and society, and to understand their different points of view on the future. We'd like to thank the committee of Dubai Arbitration Week, DIAC, of course, and then last but not least, importantly, ArtTech and Kleros, and everybody for attending. So it's 5:09. Federico, the floor is yours for about 10 to 15 minutes. Thank you.
I'm really happy to be here with all of you. So let me start presenting what is Kleros. I don't know if everyone here knows it, so I'm going to make a very short presentation. So as you know, we are in a world where the economy has gone global, digital. People are working online, doing software design or whatever type of work for customers around the world. Crypto also has given us the possibility of doing crowdfunding and investing across borders in ways that were never thought before. And we are, as you know, heading into the world of the metaverse, where we are starting to have interactions with people from everywhere. And this is going to, bring new types of disputes regarding NFTs, intellectual property, cyber crime, and everything that you will know already, right? So first, the future of disputes is going to be very different to what we knew in the past, at least in a very big segment of the economic system we have. Future of disputes regarding digital goods, mostly cryptocurrencies. Smart contract will enforce the contracts. And a very important change that never was prepared for this is that we're going to have disputes between anonymous parties, and even we can start thinking of arbitrators being anonymous. So this new economy is creating a situation where we are having a growing number of cases that they are growing exponentially, and the capacities of resolution is still, growing, but not as fast as the conflicts that emerging in this new economy. So the big question that the arbitration world needs to start addressing is how to resolve this exponentially growing number of disputes between anonymous parties in jurisdictions that are going to be the metaverse or online disputes, right? So very simple case of dispute of the new economy. Alice hires Bob to make a video for her. He delivers a product. She's not happy. She wanted something of higher quality. She makes a claim. He says, I did what I was supposed to do. And of course, it's not going to go to arbitration and ICC for a couple $100 worth of service, right? So how can Claros help here? Imagine that she sent when they make the contract, she makes a payment to a smart
Federico,
contract that is going to work. Not only the contract, he gets the money. Yeah.
Federico, sorry, we're losing you.
Yeah, let me.
I don't know if, sorry about this. Do
you
think?
Second.
Yes.
Let me turn off the video. Yeah, I'm sorry. I'm at a hotel, and I thought the connection would be better. But can you see the screen now? Can you hear me?
Yes, we can see the screen.
Okay. Maybe if you turn off the videos, for my presentation, and then you can turn it on again, so that may help as well. So, yeah, sorry about this. So Alice makes the payment into this smart contract, the escrow, and they both agree that there's going to be an arbitrator called Claros. If there is a dispute, what happens? Claros is a platform built on blockchain that's going to select a number of jurors who are going to analyze the case in an independent way, each of them independently, and they're going to assess the situation. They're going to see the contract, see the product, and then make their assessment. And a very important thing here, why Claros is built on blockchain, because this makes sure that everything is traceable and everything is auditable, and everyone knows that the process that was done was exactly what was supposed to do. And this gives parties the confidence and the trust that this is complying with what we typically call in the traditional world, rule of law. So this is why blockchain is important for arbitration and why Claros is built on this. So arbitrators look at the evidence, they vote. Let's say they decide that Alice was right, so Claros makes a ruling, and the smart contract that was holding the funds sends the money back to Alice, and this ends the case. So how are arbitrators selected? Who are these persons? One very important innovation here is that arbitrators are anonymous. Why? Well, because being an arbitrator in an online setting can make you a target of very nasty attacks on social media and all of the things that you can imagine. So it's important that arbitrators can have the possibility of not disclosing their identity. So this woman is, let's say, a video designer from Vietnam, and she works at a company doing videos, and at night she wants to make some extra money on the side. And she can, become a juror in Kleros. And for this, she needs not to disclose her identity. She needs only to buy a token called PNK. This is an asset, digital currency, that is like a lottery ticket that gives you the right to be drawn as a juror in cases in Kleros. Kleros has many different courts for different types of cases. And in this case, she will deposit her token into the, let's say, video production court. And a lot of other persons are going to also make this deposit. And Kleros is going to select, let's say, 5 of them randomly. And these are the persons who are going to have the possibility of seeing the evidence, seeing the contract, and voting on who is right? And this is where typically lawyers become very uncomfortable. Because they don't like this idea of anonymous people being jurors. And how do you make sure that they're not going to be bribed, or they're not going to be like just deciding about things they don't understand, or just being like voting randomly, the AAB, without even looking at the evidence? So this is where Kleros brings the big innovation into the table, and this is the use of game theory. So this person you see on screen is Thomas Schelling, Nobel in Economics 2005. And he made many contributions, but especially he's very well known for one that is called focal points. And it's about how people coordinate in situations where they have to reach a consensus, but they cannot communicate or they cannot trust each other. And a very simple example of a Schelling point exercise is you have 12 numbers on screen. So each of you independently pick one. If you pick the same as the majority, you get $20. If you don't, then you get nothing. So in this situation, people tend to converge and to pick the 1,000 because it looks like more natural. It looks like the one everyone is going to pick. So this is the Schelling point in this exercise. So if you take this logic into the world of dispute resolution, you can put a number of jurors who are going to see the same evidence, the same contract, the same product, and each of them voting independently on what is the right decision, and they will converge into the truth about the dispute. The truth understood in what is the consensus in the community of video producers about what is the right way to make this, to solve this dispute. When they are all seeing the same video, they are all seeing the same contract, and they are following the same rules of the court where they are working. So the point in which they will converge is the Schelling point, and it's the truth. Because each of them is incentivized through the token they have deposited to vote what the majority votes. So what happens? Let's say I want to attack the system by like voting randomly. What's going to happen is that the token I deposited, since I vote, I have a high chance of voting in the wrong side of the majority, then I'm going to lose the token I deposited for being drawn, and this is going to be sent to the jurors that voted on the majority. And so this will create a situation where I put the token, I vote randomly, I make a mistake, so I lose the token. I put another token, I vote randomly, make a mistake, and I start losing the tokens. And then that's how I, in the end up leaving the system, because I run out of tokens. On the contrary, if I make good work of deciding what is the right thing, because I look at the evidence and I make the effort of understanding the case and all that. So what happens is that I might be sometimes wrong because there is issues of interpretation. There are situations where the evidence is not clear and all that. But on average, I'm going to make more money than what I lose. So I'm going to make money as I produce rulings for the cases I have to solve. So you might be wondering why Kleros uses such a weird way of resolving the dispute. It's just because it's way more efficient than traditional ODR methods. Traditional ODR is like a mini trial on Zoom with an online hearing, and this is, of course, way more efficient than doing it like in person in a room and traveling, but it's like a 30% more efficient. Kleros has a way different mechanism design, and this makes it that it's 10x more efficient and 10x faster. Kleros resolves cases in typically less than a week, and also with the transparency of blockchain. So what we imagine is that the future is going to be divided into 3 main categories of technologies for resolving the disputes. More objective and simple claims are going to be solved by machine learning because that's more efficient and that's okay. There's going to be a set of still smaller kind of claims that machines cannot resolve because they don't understand context, they don't understand intentionality of agents and some other things. So this is where methods like Kleros or crowdsourced dispute resolution systems are going to be more effective. And then more complex situations involving multiple parties, involving legal reasoning requirements and all other more complex environments are still going to be resolved by traditional methods. Of course, more online than in the past, but still with the mechanism design looking more like what we are used to. So, and this is now ending now. What we think is that, so this justice gap that is starting to grow exponentially because of the new technologies and new economy. So we need this type of new technologies in order to increase the justice capacity to try to scale at least at the same speed that the amount of new disputes in the new world. And so the questions that we might need to ask ourselves, and I'm not a lawyer, so I don't have the answers for this. I mean, what does due process look in the metaverse age, in the age of the algorithmic economy? So we are starting to see dispute resolution methods that are based on anonymous arbitrators, where, I mean, you have situations where that would look anathema to what used to be arbitration. You know, an agent could be a party and an arbitrator in its own case. Well, that sounds like not very nice, but that's how these systems work. Also, arbitrators having a financial interest in disputes that they are resolving. So this is what some of the big questions that we need to start asking ourselves in this metaverse age for dispute resolution. I don't know, and maybe we should start to have a discussion if we need to reinvent the New York Convention for the new age of the economy and the new arbitration methods that will be required. So thank you very much. And yeah, looking forward to the discussion later.
Thank you, Federico. Very insightful explanation of your vision of the future of disputes. I want to now bring a question. I'll be asking one question to each of our panelists, but of course we encourage cross discussion. And then, time permitting, there will be questions that all three will answer. So for this segment, one panelist will lead on each question, and of course, if appropriate and if moved to do so, the others are invited to answer. So the first question is for Dr. Sabine. Federico was just telling us about what disputes, his vision of disputes in the metaverse. And he asked the question of what due process would look like in the metaverse under this context of anonymous parties, anonymous jurors, financial incentives. What do you see as the risks and challenges of decentralized justice that has these characteristics? Of course, going beyond, you know, the very risks are exactly that everybody is anonymous, etc. So the floor is yours.
Thank you. A few words. Thank you very much for Haptech to invite me and to the Dubai Arbitration Week. And yes, a few words. What is the promise? What is the promise of blockchain dispute resolution? What the challenge? What the risk? And I want to know if this promise of blockchain dispute resolution is compatible with the promise of democracy. So first, I think that justice is a prerogative of the national state, and alternative dispute resolution is a partial attack on the monopoly of the state. And so the method of doing justice can be accepted if they are compliant with the specific rules. So the question is, if they are compliant, the blockchain dispute resolution with the specific rule, and they are a legal effect if they can be compliant. And I want to just precise something. It's very interesting to note that in the model law from Koala model law, in the Article 4, we specify that dispute resolution mechanism is not need to have minimum standard due process. So I think for Kleros it's fantastic because for DAO it's that they might expect in off-chain dispute resolution, off-chain such as court litigation, but for blockchain dispute resolution, it's without guarantees of law, with non-compliance with due process. So I think in traditional law, you can have resolve dispute resolution on-chain, and the state now it's not able to enforce the decision, a blockchain decision on-chain. So I think that we need more trust in the system. We need more trust on the technological design. Maybe we have the question about coalition, risk of coalition between avatar. I think we built another system of justice just now. Blockchain have maybe a potential to create economic and social institution with Nakamoto thinking spirit. The aim is to design new solutions. And I think that blockchain is a technology for creating and executing smart contract on DAO. And I think that blockchain can provide guarantee. It's maybe a crystal box for smart contract, for complete contract. And the question is, indeed, when they are sufficient, when the smart contract is sufficiently intelligent to self-execute, they are not intelligent enough to handle situation where subjectivity is involved. So we can see at the presentation of Federico the case of the famous case between Alice and Bob, and Alice contract with Bob a website for her, and if a dispute arises about scope of the agreement, the smart contract cannot resolve. So when the contract is incomplete, you hear me? Yeah. So when the contract is incomplete, the computer code is insufficient to produce legal certainty. So the key question for justice system, it's the ability to activate a mechanism capable of producing decisions efficient and ethic. With a new logic, the new paradigm of decentralized justice pose a number of challenges in the interaction between traditional law and, it may be difficult to say that, blockchain law. So decentralized justice proposes a new approach that relies on economic incentive rather than assumption about ethical behavior. So it's a new line. Digital centralism has emerged from research in the field of crypto economy, computer science, informatics. It's a lex informatica. It's not a research about law. It's a new without law. But now to gain acceptance, it will have to convince the public and also meet the fundamental requirement of transparency, accessibility, fairness, and due process. And the last question is decentralized.
Dr. Sabine, if I may just mindful of time, if we can, please conclude.
So just the conclusion in decentralized justice is decent justice.
decent justice.
Yeah.
Very, very interesting prospects. I'd like to invite Federico to comment, and of course, Sophie, to the extent that you have also anything to comment on this. But starting with Federico, so you were mentioning this koala model law, and I saw the comment from Sophie that it only applies to DAOs, that basically there is no minimum standard of due process with respect to dispute resolution. And Sabine, you were talking about how, you know, these fundamental requirements of a justice league, of a justice system, of transparency, etc., those seem to be somewhat lacking in decentralized dispute resolution. But I'd like to invite Federico and Sophie to comment on this. What do you see as, you know, the challenges of decentralized justice? What is its promise, as Sabine was asking, the promise of decentralized dispute resolution, and how can we get there? Federico seems to be
Federico looks like he's gone off for a moment, perhaps because of his connection. So I will have a stab at this. So I take a slightly different approach to this question, and I take the approach.
You can start, Sophie. I'm here, but you can start.
Oh, are you okay? Would you like to go first? No? Okay. I take the approach of a practitioner to this, and someone who is in the business, first of all, as counsel, and now as arbitrator of deciding disputes. And what we're seeing on the blockchain and in the Web3 economy is a whole business environment of transaction that is taking place in a matrix of time that has never been seen in the traditional justice environment, legal environment. It is time that is completely compressed, that is where results are practically immediate. Transactions are one-off between people who are anonymized. And so the challenge for any dispute resolution system in that environment is to mirror these values. Now, I want to make something very clear, and Fede may not like this, but online and blockchain dispute resolution is not arbitration. Arbitration is a legal concept. It's a legal concept that is statutory in many, if not most, countries, and it is a concept that has its own matrices of time, fairness, procedural guarantees. It is what it is. And it does not fit. All of this construct of arbitration does not fit the Web3 environment because it's too time reliant, time heavy, witness heavy, due process heavy in the way that we understand it traditionally. What Kleros is offering and what other applications online are offering is a means of dispute resolution that aims to mirror the values of this new economy. It's not arbitration, but doesn't mean it's not valid. The challenges are to take these decisions off chain and see what validity they have. That's another question, and that's not something where we have a ready solution at the moment. But it is a system of dispute resolution that users of the Web3 economy may find, and the jury is out, it's still very early, but may find perfectly acceptable, perfectly decent to come back to what Sabine was saying. They don't care if they don't have, you know, all the due process ticking boxes that we have traditionally, if they get a result that they feel is fair enough on the whole and allows them to carry on trading and doesn't take ages and doesn't cost a fortune. So my approach to this is I think there is a great promise. And I think that the question for international arbitration is if we want to remain relevant in that space, we've got some work to do. We have to look at what we can offer alongside these offerings of justice, unless we, and if we don't do that quickly, we are going to become, in that space, in that online space, very quickly irrelevant. That's the approach I take to this.
Thank you, Sophie. Federico, is there anything you'd like to add to that? Otherwise, we can segue. This is a perfect segue to
yeah, I mean,
question.
I have comments on this. I mean, hopefully you can hear me now.
We can hear you.
Okay, so I mean, I think that it's important to, I mean, I don't want to get into the discussion, I mean, semantic discussion of whether this is arbitration or not. I mean, I mean, I think in this, I'm very practical in this discussion. Like, I mean, what is the goal of arbitration? I mean, if we go to the early days of arbitration, I mean, arbitration was a method that was meant for resolving disputes in a situation where national courts were not very efficient because of, well, everything that you know of cross-national and situations. And so, like, arbitration, as I see it a bit from the outside, is like, has been becoming more and more bureaucratic and becoming more and more like a court system with rules, and kind of in some way losing what made it interesting in the early days. It was this flexibility to resolve disputes in the way that parties would consider appropriate. I mean, and not judge what are their preferences. So, I mean, I think that this situation of the new internet economy brings a context where we are kind of facing the same situation that we faced in the early days of arbitration. I mean, we are having a new set of economic interactions for which all the methods don't work because XYZ, we discussed that already. And we need to have the flexibility to start thinking, I mean, how can we provide solutions to these customers that require these solutions to keep their businesses going? So if you want to call that arbitration, or you want to call it something else, I'm not going to go to war over that. I'm fine. I mean, I'm just saying that we need to put the focus now on the first principles thinking and what is the service that these methods, however you want to call them, provide to customers. That's the point of view from which I approach this matter. And Kleros is just one of these solutions. I mean, there is Kleros, decentralized justice, but there is also machine learning. So it's only one small part of a bigger movement of legal technology invading different elements of the legal world.
Okay, that's very interesting. So Federico's point of view is that this is just one option amongst a plethora of fora that are coming available for this new world. I just want to pick up on something interesting that Sophie said, that the question now for the international arbitration community is, how do we remain in this space of Web3 and the metaverse, et cetera, and stay relevant to it? What are your thoughts, Sophie? Do you have any ideas on how we can remain relevant as international arbitration as a method of dispute resolution?
I think it is a very tall order to remain relevant in the current construct. However, it is a resourceful field, and you have institutions such as the Vienna International Arbitration Center that are starting to look at how they as an institution can remain relevant in this space by providing an offer of arbitration that is very, very time limited and still offers guarantees of procedure and fairness that would be recognized outside of the blockchain system, so by national courts. So we're looking at this. And also in Dubai, I mean, you have the brand new Digital Economy Court, which is a state court. It's not arbitration, but it is very much positioned at the center of this space. And as I understand it, the barristers at the helm of it, Michael Black, KC, is, in the process of developing procedural rules that precisely aim to square that circle, provide justice that mirrors the values of the users of that economy, and at the same time is justice that is not just decent, but as bulletproof as it can be in that space. So I think it's a very exciting development. I think arbitration should look very closely at what the Digital Economy Court is doing, because I think institutions have a lot to learn. And the challenge for us to remain relevant is to provide a high level offer of justice, because not all disputes are low value in the Web3 economy. Some of them are very high value indeed. And for that, maybe you need a dispute resolution system that is a little bit more bells and whistles than what Kleros and other applications might be offering for other types of disputes.
Hey, thank you, Sophie. And just to circle back to Federico, and I think this might be kind of an easy question for you. But, you know, in terms, to the extent that you said that Kleros is just one offering amongst multiple, as we try to imagine the future of dispute resolution in this new world, what are, you know, kind of the bars to its widespread adoption from your perspective?
Many. I mean, this is still a very experimental technology for resolving disputes, trying to address situations in a market that has been, well, I mean, forever. And the first important thing is to ask ourselves, keep testing it. Kleros has resolved for now around 1,300 disputes, which is like way more than any potential, I mean, competitors, but still it's not a lot compared to the amount of disputes that have been resolved, that are resolved daily by, I don't want to compare it to arbitration. Let's compare it to, you know, how many disputes are resolved by eBay dispute resolution systems or by Facebook claims management systems. It's still very early. The incentive system is it's very innovative, as you have seen. And of course, this creates a lot of frictions because it's about explaining how this works, showing that it works, testing it. So for now, the main challenge is to try to understand better which are the use cases where the use of decentralized justice tools is going to be like less, with less friction. Of course, I wouldn't imagine using Kleros to resolve, I mean, multi-million-dollar claims. I mean, maybe in the future, but it's still certainly not at the hand at this moment. I wouldn't even imagine this, and this is a thing that lots of lawyers even. The first question they ask sometimes is, okay, do you want to send people to jail with Kleros? No, of course we don't want to send people to jail because this is not meant for, I mean, criminal stuff. So a lot of what is a lot of work we do is education of people and try to identify what are the exact use cases where we think this can add value because it provides resolution cheaper and faster than other methods, and where people are also willing to accept it. But sometimes Kleros can be objectively better than other methods, but because of the way in which it works, I mean, people just prefer to go to traditional methods because they trust them more, because that's what they know, and that's fine. So lots of the work we need to do in the future is to education and communication.
Thank you, Federico. Another question.
Can I just add? Sorry,
go ahead, Sophie. Yes,
no, I just wanted to bounce because I think that's a very important theme for me anyway. Again, as a practitioner, what is central to all of this, to the offer of dispute resolution in the business landscape, be it in the Web3 economy or in the traditional economy that we know, is that users go, when they have litigants go to a forum that they trust. Trust is very, very central to what we do. It sounds obvious because you take it for granted, but that's what it is. They trust that the system will provide them with a decent solution and that it will be fair and that they will understand the outcome. And so at the end of the day, those economies will vote with their feet. Where if they find a system that works for them, and if that system is Kleros or the eBay system, which worked wonders when it was devised because it addressed and mirrored the value of the eBay community, then that's fine. That's fine. That is a justice system that works. Now, the bigger questions, and that these are questions that are beyond just the little cosmos of international arbitration. The bigger question is, do we want to have a justice system where financial incentivization is at its core of the jurors, of those who dispense justice? That's a bigger question. My own view is that the landscape slide that Federico showed in his presentation, where you have essentially horses for courses, as they say in the UK, a type of dispute resolution for a type of dispute, I think is the way forward, and it allows choice, and that's a luxury, the luxury of democracy.
Yeah.
Thank you.
Let me add one more thing about this.
Federico, yes, go ahead, please.
So people, I mean, they often ask me, do you want to replace arbitrators, judicial arbitrators with Kleros? I mean, I'm like, no. I mean, what I would consider a huge success of Kleros is not Kleros being used like in oil and gas disputes. I would consider a big success, Kleros, I mean, being able to address like very small claims. I mean, the $10 claim, $20 claim, very efficient. I mean, I would consider it a huge success if we can bring micro justice, like for micro transactions, because that's what changes the world. I mean, that's what gives a person who lives in Argentina or in Botswana or in Philippines or whatever, the possibility to have a contract with people from everywhere in the world for small claims. And this is what gives them access to the world economy and to, and to have access to things that typically were only accessible for people who lived in countries with rule of law and advanced economies. So that's what Kleros needs to become. It's more like a very high volume and small value claims. And Kleros could also resolve higher value claims, but that's not what I would consider the main success and the main focus.
Thank you, Federico. Sabine, do you have anything to add on this?
Maybe I want to speak about the Mexican case, and maybe it's the evolution of the tool of the protocol of the Kleros protocol, because in 1st of September 2020, two parties decide to include an arbitral clause in a real estate leasing contract governed by Mexican law. There was a standard clause where party appointed an arbitrator and set the arbitration rules in traditional New York Convention. So the novelty of this particular arbitral clause was that the party instructed the arbitrator to use the Kleros protocol to govern the substance of the award. So I want definitely debate with Federico and Sophie about this case, because it's a mixed mode. It's a mixed mode for arbitration and maybe for future of law. Yeah.
Thank you, Sabine. Sophie and Federico, I invite you to respond.
I will let Fede go first, obviously, because that was quite a landmark for Kleros. And then I can certainly, if there's anything that I want to add, I will do so. Fede, please.
Yeah. So what happened in this case is that this person, Mauricio, the arbitrator who did this experiment, so he wanted to use Kleros not as an arbitration, seat in itself, but more as a tool that assists arbitrators in their job, right? So this arbitration clause, designated Mauricio, who is an arbitrator, official arbitrator from Mexico. He has an arbitration center there. And so what happened is that the dispute started. Both parties, landlord and tenant, sent their claim to Mauricio. Mauricio uploaded this evidence into an interface that sent the case to Kleros. Kleros produced a ruling with 3 jurors, and they unanimously ruled in favor of the landlord, who claimed that the tenant had not paid the rent. And so then Mauricio took that information from Kleros and then went to the judge and told the judge, look, there was this arbitration clause that designated me as arbitrator, and then instructed me to use this method called Kleros. I use this method, and I come back to you now, and please enforce this ruling, because this is what parties wanted, right? So the judge said yes, and that ruling was enforced, but it was not a Kleros ruling per se. It was more like a Kleros assisting the arbitrator in order to produce this ruling. So this opens like an
expert, like an advice.
Yeah. So this opens like a big avenue for Kleros application, that it's not as an arbitrator, but it's more like a tool that can be used as part of a traditional arbitration process for conducting some more factual analysis, like more expert witness work. For example, there is you could have a part of oil and gas dispute or a construction dispute where there is a part of the dispute is about the quality of the materials that were used in the construction. And so now what you do is you call like expert witnesses on both parties, and one says yes, the other says no. So in this situation, you can have a Kleros jury, assess only that specific factual claim done by one of the parties. Or in an IP or brand dispute, you can say, okay, this brand looks confusing to users or not, and you could have like a jury, seeing if this brand seems to be like another brand. So you can have like a kind of a mock little trial, a little panel to assess more factual situations, which then will be taken by the arbitration process as an input that is going to be used for making a decision. So this is another use case of Kleros where it's used more as a tool. And the advantage of this is that it kind of doesn't have to deal with all of the discussion about the New York Convention and about, well, of all of these legal discussions that we typically have. And the good thing is that, so Kleros is a very flexible tool and can be used for a lot of different things. Many of those we're not even aware in the team who develops Kleros. And this case that Mauricio developed, we didn't know about this. It was his idea because he's an arbitrator and he deals with this at a daily basis. And he saw Kleros as a way that could help him resolve the substance of many of the cases he has to deal with in a daily basis. So, and that's another approach, and that's perfectly valid, and it worked in Mexico. And now there's people trying to do this same study and to see how this type of approach fits in legislation. I think in Spain, there is people in France, there's people in Guatemala and many other countries. So we'll see.
Thank you, Federico. Sabine, do you have any response to that? Otherwise, we can move to the next question.
Yes, definitely. I think that it could be a tool, a new method, and maybe a hybrid arbitration. Yeah.
I think it's a fantastic demonstration of what Federico was saying about the flexibility of the tool.
Yeah.
Looking at it from the arbitration process perspective, that the use of Kleros in that way, or any other assistance in dispute resolution, throws up very important question in the delegation of the arbitrator role. When an arbitrator is appointed in the traditional arbitration space, it is appointed in its individual capacity. And that means that in its contract with the parties, an important feature is that the decision be made by that arbitrator or that tribunal, not delegated or farmed out to other tools. Now, if that is, we are going to start using other tools and have a hybrid, if that's the way forward, I think that's fantastic, but it does mean that the parties have to be made aware of this and that the delegation is circumscribed and understood by everyone to be a delegation, rather than have to avoid the danger of having arbitrators delegate wholesale certain disputes, take the decision back, not verify it, because often it might not be verifiable, and then bring it to the state court and say, well, I'm taking this is my decision, and I was assisted by this tool. So I think it's, again, a very novel way of looking at this. I think it definitely can be the future for many things, but it does mean, again, rejigging the arbitral construct structure that we're working with, which is regulated, whether we like it or not. It's less regulated than state court litigation, but it's still regulated a fair amount at the point that we're talking about now. And if Mexico allows this, some legal systems also allow flipping a coin as a method of dispute resolution if the parties agree. So I think we have to be, again, there has to be a little bit of rigor in the way that we approach this.
Thank you, Sophie. If to the extent that someone might say that this could count as some sort of I want to say award washing of the Kleros Award by being ratified through the court system and then by being ratified by an arbitrator and then going through a court system, what I suppose what sort of answer would you give to that? And that also brings me back to what you were saying earlier about how Kleros provides this choice, this option of fora for this new world. how much choice are we able to give was the question that you asked. I mean, do we live in a world where the justice system is able to accept 100% choice, and where state courts, when they review these sorts of decisions later on down the line, can you imagine that at some point we will not have that sort of the check of due process coming always at the end and potentially nullifying something? Because even in arbitration, which is consensual by nature, there is always that shadow of due process that the New York Convention also allows as a potential check on the award. So can we really do away with that for these new technologies and say, well,
there is no reason why we should. I think it's up to us to draw the line somewhere. I mean, in the example we just,
this is a philosophical question. Should we allow people to this extent to say, yes, we agreed that we don't see a problem with due process, but even if later on it was going to come up that there was potentially one, we don't care, and we sign up to that up front.
So again, taking a practical answer to that question, I can tell you from my now several years of practice that parties are willing to agree whatever before they have a dispute. And then after they have a dispute, they care very much about due process, I can tell you. And so the answer to your question is, due process has to remain, and it has to remain in certain forms of dispute resolution. It does not mean that it has to be as heavy to carry as we have now in a full-blown arbitration process. It can be trimmed down. That's my point. It can be trimmed down, but absolutely, you have the whole point of justice, the whole meaning of justice, whatever form it takes, is that it makes sense to the parties and it is fair, and it is that fairness point that is being turned on its head in the Web3 economy and by applications such as Kleros, but it doesn't mean that it disappears. And the partnership between arbitration and other means of dispute resolution is very much in our hands for us to draw the line, for us to have that dialogue, exactly like we're doing now.
Can you imagine a workable solution, just sort of putting ideas, and I would love to hear from the panel and also anybody in the audience on this. Can you imagine a solution would be to have a specialized forum such as the one in Dubai that will set the standard for this due process for the new world, the Web3 world, the metaverse, and it would be the sole forum for checking awards, and from there they can move on to local, more state courts who would have to enforce them under a reduced version of the New York Convention, let's say, where the state courts has a reduced view or modified view. So there is a specialized forum that checks due process that is appropriate for this new world. And then from there, we hope that other courts by treaty or otherwise adhere to that check that has been done by this exclusive jurisdiction. Do you see that as a question?
I mean, your question assumes that that those decisions need to be taken off chain somehow, and into state courts. That's not a given at all. And in a large majority of cases, everything may remain on chain, and as long as the wheels keep turning, that dispute resolution system on chain will be part of that microcosm. But what you're positing may well be a very viable solution for those instances, which at the moment we're struggling with, is how to make those on-chain decisions live or livable or have some validity in the off-chain world. And it may well be that this is exactly what the mission of the new Digital Economy Court.
Yeah. Sabine, Federico, any comments on this?
Yes, I think that international arbitration, it's more flexible alternative to national court system, will play a key role in this. And I think that the dispute resolution framework will have to be reinvented with the new technology parameter of the new environment. And maybe we can implement in the smart contract a clause, open clause, we can imagine the choice between maybe clearance mechanism, and because it depends of the case. Definitely, it depends on the case, and we can imagine a open smart contract to propose a lot of hypotheses. Yeah.
I was listening to you, Karen. I mean, asking your question, and I was kind of thinking, this is the kind of question that people were asking themselves in the 1950s when they were started thinking about the New York Convention. I mean, they said to themselves, we have this new world economy that is going to be governed by, multinationals and governments and big contracts. And I mean, obviously, courts are not a great solution to resolve lots of these claims because of what you know already. I mean, what type of processes should we, use for this? And how can we make sure that these arbitration agreements are going to be enforced in all of the, jurisdictions of the world, or as many as possible? Otherwise, what's the point, right? So we're kind of at this point in the world of decentralized justice and, blockchain and law more generally, thinking maybe what should be, what should be the features of a decentralized justice system in order for us to accept it? I mean, what should be the standards that this system follows? It should be, I don't know, for example, be built on an open blockchain, or it's okay if it's built on a permission blockchain. I mean, there are a lot of questions that are like the equivalents of the questions that were asked in the 50s in the New York Convention drafting time, and that we are starting to try to figure out now, because we are kind of in a similar situation historically because of the economic change and the need of new resolution methods. And I think that there's going to be a lot to be learned as more actors enter into the industry. So for now, it was only Kleros doing this, and now we are starting to see other people becoming interested in adopting an approach like ours to resolving disputes. And with this, I imagine there's going to be like more people interested in drawing standards for how this method should work. And and so this is something that is going to be, I think, built in the next, 5 years. And the Koala model is going to be a big part of this discussion, I think.
Thank you, Federico. But just to sort of bounce off of your question, what to you are those minimum standards? Are they just the parties consented at the time that they entered into this, or is there something more? I mean, for me, at the minimum, it is, and the way in which you have always thought about Kleros is, yes, parties consenting to the contract, it's enough for us. Then you have other situations where you have these online contracts that users sign in websites that nobody reads them. So what are you actually agreeing to? I mean, and so this poses a new question. Maybe there should be a contract standard of when you are speaking about addition contracts. But for us, up to this point, at least the main standard was people agreeing to it. And I imagine the community and people doing research in the Koala framework and other research in law and blockchain to bring more the answers. And I think this is where the expertise of people who have been already working on arbitration for a long time can be very important, because as builders, we are dealing also with very practical things of building in blockchain, like scalability, and the transaction cost is very expensive, and lots of other things. And our focus is not always into building these standards, because we have other practical situations, to resolve. So everyone who wants to contribute to this discussion is very much welcome, and this is going to be a very big field of law in years to come. Thank you, Federico. And I take your point about how meaningful is consent, for example, when it's to hundreds of clauses in general terms and conditions that are hidden at the end of the contract. And going off your point that this is a question about the minimum standards and what those should look like, that can be answered by experienced practitioners, I take the question to Sophie and Sabine. What is this minimum adapted due process for this new world? I mean, can we imagine what it looks like, or is it too case specific that it's somewhat difficult to imagine at this point? Can we start to draw its tenets? And how can we really differentiate it other than to say that it's something less, but it's more than zero?
I think this is exactly the sort of question that brings you back to what is it that makes a dispute resolution system fair? Very, very basic, law 101 question, equality of arm, ability to put your case. And you can stop there. You can stop there. And you don't need to have 3 or 4 or 5 rounds of reply submissions. You can put your case once. I come back to baseball arbitration as a good model, actually, from which to start. Each side puts in their desired result, and the decision at the same time, the decision maker listens to the or looks at the evidence, more likely, because it's going to be digital and placed on the blockchain and transparent, and then comes to a view, opens the envelopes and chooses the decision that appears to them to be the fair. And that doesn't have to take ages, but it's definitely more than zero. And it doesn't have to be, as I said before, as heavy as what we have now. What we have now, in terms of due process and procedural justice, and because of the oversight of national courts, because the system is no longer as black a box as it used to be, arbitrators feel that they need to explain in a very large manner how they came to their decision, because it's going to be read by people outside of the ecosystem of the dispute. And this has been, I think, the trigger of arbitration becoming more burdensome than it was when it started. There is an oversight, and that oversight is a serious one, and it is often wielded by the parties as a threat during the arbitral process. If you don't give us what we want, you know what's coming. And so when you strip all of that and you go back to what is due process in the Web3 economy, I think the answer can be very simple, and it can be a lot quicker.
Thank you, Sophie. Sabine?
Let me just comment something.
Oh,
I mean, which is some we discussed with Sophie a lot of times. This is the first time I hear her say this about how parties sending the evidence at the same time and proposing their preferred outcome. This is a game theory. Why not one party before the other? Why at the same time? And why they should claim what they want from the dispute? So this is pure game theory. How to deal with strategic behavior of agents, and this is exactly what we deal with at Kleros every day. How to produce a system where agents have the right incentives for the system to reach the correct outcomes. So now, at least we are speaking the same language. So this is a very big, step forward.
We were always speaking the same language, Federico, just from different viewpoints.
I know.
Good to see this this awareness of having been speaking the same language all this time. Sabine?
I have just, I think that would be very interesting if we compare the both system with decision. So with traditional law, the issue was maybe not the same decision, and with the game theory. And so we can have maybe statistic, I don't know. So compare the both way of treating the dispute, yeah.
Thank you. Federico, anything else to add? Sophie, anything else to add on this point, or?
No, I don't think so. I think maybe Karen, attention should be brought to the very interesting comments in the chat. We've had comments from Andre Cardoso out of Brazil, and my colleague Sean McCarthy, who is actually behind the scenes of this call today. And maybe it's worth summarizing for the audience.
Absolutely. So for Andre, we had a comment with respect to the losing party caring mostly about due process, which would motivate them to challenge an award later on after having, as Sophie said, potentially agreed to anything and everything at the moment of courting its counterparty. That's an interesting comment from Andre commenting on Brazil. From ArtTech, we have a comment that Federico talks about building Lex Cryptographia, which is the on-chain jurisprudence, and noting that the standards accepted there could and potentially should inform traditional states courts' attitude, just as other practices in other industries are. I'm interested in digging a little bit more into this comment, the on-chain jurisprudence, and how it would inform state courts. Can you elaborate on this a little bit more, please?
Sean, please.
Yes, I hope you can hear me. Yes, no, I suppose it's something that has been discussed, I suppose, in the past 10 to 15 minutes, and it's just the same way that we treated maybe 50, 100 years ago Lex Mercatoria and kind of practices and business usages in different industries. And I think it can be extended into the Web3 space. And again, with I mean, even we see 1,300 disputes from Kleros. There's obviously going to be a body of, I suppose, again, we could say standards, we could say methodologies for deciding disputes. And I think it would be short-sighted of national courts as these bodies of law grow to ignore them and just to try and transplant traditional legal principles and resolve disputes in what they see as a traditional way, rather than actually taking what the people who are in this industry 24/7 and the lessons they're learning and adapting on them and kind of enforcing them. And I think this is kind of where I see, and I'm always interested to hear what Federico says about Lex Cryptographia, because I think it's something that it's very amorphous now, but I think it will probably grow to be something, some important piece of legal principle.
Federico, do you have anything? Yes, thank you.
Yeah, I mean, so one thing about jurisprudence. I don't know if like national courts are going to take jurisprudence formed in like online dispute resolution systems. But what I can tell you is that we do see in Kleros jurisprudence. I mean, when jurors in a case have to make their argument on the case and make a decision and justify why they made the decision, they very often mention past cases. I mean, as you see in traditional, court systems, because, and they say things like, okay, as happened in case 637, so we took in consideration this and this aspect to make this decision. So in this case, which is similar to that one, so we should take the same consideration. So you see that happening, and you see that happening like in real time and very fast. So what happens in traditional legal systems over, decades maybe, it happens in matter of weeks in Kleros. So you see, this should be, it must be some feature of how communities of humans make the rules and adapt them to changing circumstances and new cases that are arriving. But you definitely see this type of jurisprudence being formed. And so this is something that hopefully someone, we have a fellowship program at Kleros. If you want to join, this would be a really interesting research topic, for you to take a look at. How this jurisprudence is being formed in this system, because it's fascinating. And then about Lex Cryptographia. So as Sean said, this is kind of a bit of not very well-defined concept. To my understanding is these rules formed by a smart contract with the code, and that prescribes how a system will work. And the fact that it's done with smart contracts means that everything is going to be executed and enforced exactly as is in the code, and no one can make any arbitrary changes into how the process works. Differently to what is called Lex Informatica, which is the rules that are working in traditional Web 2, like the platforms, like Facebook can change the rules of how it works, I mean, unilaterally, because they own the servers, so they can do whatever they want. So Lex Cryptographia brings this element of, okay, these rules of engagement that we have in this platform, I mean, social media or e-commerce or whatever platform, are going to be made by the users. This is the idea behind DAO. So users are those who will decide and vote on what are the rules. Users are also going to be involved in how the disputes are going to be resolved in these platforms. So, and this brings us back to the discussions we had at the beginning. So this is democracy. I mean, because we kind of see, if you want to bring this to a political, situation. So this kind of is a transition between, like absolute monarchies to democracies or republics, where in the monarchies, people were not citizens, or they were subject more than citizens, so they didn't have any say or vote in rules or dispute solution. But they do have that in democracies, and this is kind of what's going on now in the online world, and that's, I mean, in my understanding, what Lex Cryptographia needs to figure out now.
Very interesting, thank you. I mean, we really could go on for a very long time on this. My intuition is that the jurisprudence in Kleros would for sure give an understanding of the standards in terms of substance, in terms of, just as the Lex Mercatoria is, I mean, it's the law of merchants in the sense that it sets the standards that merchants want. But we tend to think about it more in terms of substance than in terms of process. So I would be interested to seeing for sure whether there are any standards. I mean, certainly we'd be able to see some patterns in terms of what the community believes to be the minimum procedural law that it requires, other than, questions like, what should this, what should this product look like? What should, in this digital economy, what are the minimum standards in terms of the supply of what the subject matter of the contract is? I also want to acknowledge this very interesting comment from Andre that adapting or retrofitting the due process principle to the digital world already exists with the example of electronic signature of contracts. I think that point is a good one and very, very well received. Anything else from our panelists? I am mindful that we are at our time and we could go on, and I'm happy to go on. Just mindful of your own time and your commitments. Just to wrap this up, and we can continue afterwards, but thank you very, very much to each of our panelists. Again, thank you to ArtTech and thank you to Kleros for this fascinating conversation. I think that we did kind of move forward in some interesting ways that I don't think anyone was expecting. So thank you for that. Thank you for the audience and for the interesting comments and the debate. Again, I'm happy to continue and keep going. We really cannot get enough of this conversation, and an hour, 15 minutes is not enough, but I'm mindful that some people might have other commitments. So thank you. I'll still be here. Thank you for everybody for attending.
Thank you very much, Camille.
Thank you.
I just want to have one last comment. I mean, so for those who want
I'm interested, Federico. We could go on for hours. I'm ready. I'm comfortable.
I mean, I think that the most important thing, I mean, for us to have in mind here is that, I mean, what is understood as like due process is also not, I mean, objectively determined. So this has changed over time.
Yes, that's absolutely right.
Yeah. So that's kind of the question. I mean, is due process, as we have understood it in the last 50 years, 400 years, or going to be the same thing we understand as due process in the future? And there is one example I like to give, because it kind of, I mean, tells us that sometimes that we took for granted can be very different. And it's not from the world of law, it's from the world of, I mean, encyclopedias. Wikipedia, when started, I mean, brought a very different model to how you can build an encyclopedia. I mean, people from the 18th century, we knew, Diderot and D'Alembert and, and the encyclopedia and all that. So that was the way in which Britannica had built encyclopedias for like centuries. And then we had a new model that was Encarta, that was digital and online, but it still was the same old model, of Britannica, that there's one editor, making a team of writers about different topics. So, but when Wikipedia came, it kind of, people were like, this is never going to work. How can you have anonymous people from the internet resolve, articles and create content? This is going to be a very bad encyclopedia. And it turned out that since Wikipedia figured out the right mechanism design, let's call it, the right incentive for users to engage with the platform and with each other, it worked. And the previous models, who uses Britannica now? So what Wikipedia showed
people
that,
who feel nostalgic.
Yeah, exactly. Yeah. But Wikipedia showed that if you come up with the right incentives and people start to at some point adopt it and it works, it can really change some things that were done in a very traditional way for centuries. Just need to prove to make it work and prove it works, and people start to trust it, and then people switch. Because it's better, right? So that's kind of the way in which we should approach these due process considerations, I believe.
And this kind of brings me to what something that Sabine and I were discussing just yesterday, actually. So one of the interesting things about the concept of decentralized justice is sort of this, to some extent, the deprofessionalization of the legal profession. Where you have I don't want to say unprofessional, but non-licensed parties. Sure, jurors don't have a license, but you don't have that judge that's a member of a bar. You don't have the traditional attorneys there. So in that way, it's sort of like we were making the comparison with Uber, where previously, at least in certain countries, in order to drive a taxi, one needed the license. So there was this sort of regulatory bar or barrier to being able to become a taxi driver that was beyond just simply being able to drive and having a car. And now with Uber, it really is just that requirement. Like, you need a car, you need to have a driver's license, and you have to have a background check, but you don't have to pay money to enter that sort of association of taxi drivers. And this is somewhat similar. To be able to enter this sort of game where typically people would go to law school to sort of be in this realm on a professional basis, decentralized justice and the anonymous juror system takes that away. And Sabine, do you have anything to add or any comments on that?
Yes, definitely. I have the impression that maybe you have no car, no license on you, and it's okay. So maybe Federico, you want to comment about?
So just to say, you're saying Federico
yeah,
is
sure.
okay with there just being like not even a car.
Yeah,
right? Like really just anything, just come to the table and join, and the incentives are solid enough to make sure that the solution is right in the end.
The question I would ask, Kleros is not meant, Kleros is not going to replace lawyers. Kleros is going to be like a replace.
Oh, thank God, Federico.
I say that at every conference. I always say that this is not going to replace lawyers. It's going to resolve those claims that lawyers are not interested, or because these are small claims. It's going to replace the claims system at Facebook, at eBay. It's going to replace all that for sure. So it's not going to replace arbitrators in like oil and gas multi-billion-dollar disputes for sure. So don't fear. But at least for argument's sake, let's say Kleros wanted to replace lawyers. And so I would imagine if the system of incentives, is right. So people who actually went to law school and have all of these years of training and working on this and experience, they should be be way better than other jurors because they have all this training. And so so they should be the winners, right? If my logic is right. Otherwise,
you're thinking they should benefit the most financially. So they just sort of rethink their profession in that way, and they
I mean,
should, yeah.
Even if I don't know that you went to Harvard Law School or whatever law school, I mean, your training by having gone there should be way better, and you should be way more coherent, you know, in your assessment of cases than other, you know, jurors that didn't go to, I mean, as good a law school, right? Because you have more training and you have a better training. So it should not be, I mean, lawyers should not be fearful of Kleros if they see it from that perspective, right?
Do you have any advice? This is one of the questions actually that we had thought of. What is your advice? And I appreciate that you're not an attorney by training, but just from your vision of what you know the practice of dispute resolution is going to look like in this decentralized world. What is your advice for attorneys getting ready for this, you know, for that new coming?
I think that my main advice is, I mean, that you can only actually learn this, like, I mean, getting your hands dirty, you know, in these systems. I mean, because you can read as many books as you want, and but if you haven't never been like a juror in Kleros, and you have never been in that situation of having your money at stake and having to make this decision and thinking how others are thinking, so you only have like an abstract view of how the system works. So. And this is true for Kleros, but it's also true, like, if you're interested in machine learning for resolving claims, I mean, you don't need to become a machine learning coder or anything, or data scientist, but at least try to go to these companies doing that, and try to be a user of their products and see how they work and see how they don't work, but you have to be a user of these technologies in order to actually have a good understanding and an opinion. And then if you are like in the early stage of your career, I mean, and you want to be a lawyer, what I recommend is try to get a job at startup doing something that you like. I mean, and some innovation that you are interested in. I mean, if you want to work at Kleros because you like game theory and centralized justice, we have lots of opportunities for internships that you can come and work with us, or you can go to an AI company or whatever, but try to work in one of these startups so you can see how the people who are building them are thinking about the problems of the future and how they are seeing how to solve them. So I think this is very important. And so what we are going to see in the future of law is this convergence between traditional law and this other ecosystem that is kind of dispute resolution, but not really, that is, customer service, claims, the online ODR system from internal Facebook. Twitter has like an internal claim system. So there's a convergence between these two industries. And this is going to produce lots of misunderstandings and lots of situations of, lack of trust between each other. So, I mean, if you can try to learn more about these other ways and approaches to resolve claims, learn about how ODR works in eBay or in Twitter and other online platforms, that's also going to be like a big learning about the future of law.
Thank you. I think that's great. That's definitely great advice. Like get in early and try it out and get your hands dirty into the process. Sabine, anything to add on that?
No, maybe it's exactly what you say, Federico. Maybe that can be a tool for a lawyer. And for
definitely.
And then finally, one last. Sorry, go ahead.
No, just that. Go ahead.
I was going to say another thing that sort of occurred to me that we didn't have the opportunity to raise, but taking into account, this ambition of Kleros, one of its many ambitions is, you would be perfectly happy for it to be adapted for the microeconomy and smaller scale transactions, where arguably we don't need a lot of due process by nature. One can imagine that, for small stakes disputes, the question is always, sometimes it's not even worth the effort for really small stakes disputes, under $100, et cetera, or whatever currency, whatever the appropriate amount for the appropriate country. It's not really worth the effort to go to court, even to small claims court, the gas for the car to drive to the courthouse and filing the paperwork, and the time might not even be worth it. So I think in that case, maybe reduced due process would not be entirely problematic, or even problematic at all, even down the line. So I wanted to get your input on that, Sabine, and of course also Federico and anybody else from the audience. And I'm really glad to see that almost everybody is still here. So that's very exciting.
Federico, start.
Okay, yeah, I mean,
It's excellent
important
panel
here
with
to
taking everybody to their chairs.
Yeah.
you know, that's the quality test, you know. Yeah, it's just
Yeah.
here. So I mean, you know, the reality is that, I mean, sometimes legal professionals are so much focused on due process. I mean, that they don't see that in some situations that you very well mentioned, Karen. I mean, due process, I mean, is perceived differently. One very interesting example is, you know, e-commerce platforms. You know, you are a user of eBay and you have a claim. I mean, you bought something and you have a claim with the seller, and the internal system of eBay says that the seller was right, so you lost. I mean, you don't go to court. You don't go to consumer claim, you know, court. I mean, some exceptions go there, but almost 99% of the people don't go there. They just are, I mean, pissed for a day, and then the next day they are again buying in the same platform where they lost the case the day before. So that's the way in which, you know, people psychologically, you know, behaviorally address these situations of resolution in these platforms. Even when they lose and that they are not happy, they still keep using it because it still gives them value, right? So that's, from a practical perspective, you go and check how many actual, you know, solutions made by one of these platforms of e-commerce, and that how many times a pissed customer ended up going to court against the company because of some difference in a ruling for like a couple of $100. So it doesn't happen empirically. So that's why we don't need to worry that much about those kind of scenarios, because these due process considerations are, in general, I mean, kind of more abstract than real.
I think in certain contexts, you may very well be right that empirically, you know, people don't tend to make a fuss about it or to insist on it in a very specific context of disputes. Whether we're ready to take that as a principle and remove it entirely on principle, I think that's a question for the future. I'm conscious that we don't have much time left on the web link. Sabine, anything to add?
No, it's okay. No, I think it's a genius tool, and I think they must working in progress like my English.
Thank you so much, Federico. Thank you so much, Sabine. Thank you also to Sophie. Thank you, Sean. Thank you, everybody who stayed. I mean, we genuinely could go on for a while, and please be on the lookout for any future panels with Artec, with Claros, with Sabine. We'd be happy to pick up this conversation later on in time. And yeah, thank you again. I had a thoroughly enjoyable time, and I hope you did as well.
Yeah, thank you very much, Karen.
Thank you, everybody.
Yeah.
Have a great
evening.
evening.
See you next time.
Thank you.
Bye-bye.
Thank you.
Bye.
Thank you. Bye.